Hello and welcome to Tea Talk, our weekly show where we discuss latest updates, news, what's buzzing on the social media, as well as all you need to know to have that ease of living in this country. Now, what lately has been the talk of the town is unfortunately the unfair dismissal, or as we say, illegal termination in the Sultanate. And for that matter, we have one of our all-time favorite guests joining us today in person. So let's welcome Mr. Yasin Chaudhry, who's the Associate BSA Al-Rashdi Al-Barwani. Thank you so much, Mr. Yasin. It is a pleasure to see you after maybe 2 or 3 years now.
Thank you very much for having me. I'm always pleased to be here on your show.
It is always a pleasure. Thank you for always being a part of TTV. You know, you're always a call and a message away. So thank you so much for taking out time and joining us today and to talk about this sensitive topic, which is the illegal termination. Now, before we get into details, Mr. Yasin, could you explain the difference between the illegal or legal termination?
Well, we'll go to the termination point. Actually, before we go to the detailed matter of termination, it linked with the type of contract that normally prevalent here in Oman. And under the law and in broad categories, generally the contracts falls within two types. Either it's a limited term of contract and it's unlimited term of contract. So, if the contract of employment is a limited term of contract, it means the term is for a particular period. It can be 6 months, can be one year, can be 2 years, depending on a particular project that the employer need the employees for. By contrast, there is another type of the employment contract that's unlimited term, which means there is no bound or the limitation in terms of time in relation to the employment contract. So there is no time boundness there. And so when you talk about the termination, depending on the nature of the agreement, the nature of termination also will vary. And also the requirements, the benefits, and also whether it's legal or illegal termination, that also mostly vary on the type of the contract a particular employee has. Right. In a plain language, the way it's formulated under the labor law of Oman, it says any termination which is not in accordance with the labor law, it's illegal. And it's a very general formulation of law. Of course, it depends on specific cases and specific situations of an individual employee. So it depends on the interpretation of the law by the court as well, how the court views a particular scenario, whether the termination has been done according to the law or no, and whether the parties have acted within the bounds of law. And also the procedural matters that need to be followed in case of termination. So depending on all those scenarios, then the court will decide whether a particular termination is legal or illegal.
Right. You already explained the few steps that should be followed. Could you tell us in detail what steps should be followed by an employer when he or she is terminating the contract of an employee, be it Omani or non-Omani?
Generally, depending on the grounds, we'll come to in a later stage what are the grounds for the termination and under what article actually employer is going to take recourse for the termination. So generally, of course, when an employer wants to take a termination decision against an employee, he should be giving a fair notice to the employee, maybe 7 days or 15 days, depending on the nature of the business and also depending on the reason why he is taking the termination decision. So the general procedure, just to avoid the illegal termination, because illegal termination will have very serious consequences to be inflicted on the employer. So yeah, depending on the various scenarios, and also just to have a general idea how to proceed about the termination, what are the requirements, the process. I would say better the employer should give a notice at least 7 or 15 days, and also give him a fair chance to reply. The employee should have a chance to reply if he wants to make any representation, and if he wants to make any reply to the allegations made by the employer. Based on that, the employer can take the decision going forward.
Right. Mr. Yasin, talking about illegal and legal termination, and talking about giving a notice period, and also for the employee to serve a notice period, is it legally correct to terminate an employee on his or her first offense? Like, for example, if someone commits an offense, it's the first time that the person has committed an offense. Is it legally right for an employer to terminate that employee?
Well, it's the termination decision mainly comes under 2 articles of the labor law, Article 40 and Article 41. Under Article 40, the termination is immediate. The employer can take the decision of termination if the conditions mentioned in Article 40 are fulfilled. So he doesn't need to serve any notice at all. If it's under Article 41 or also some other various provisions of labor law, yes, if it's the first offense, depending on the gravity of the offense, depending on the nature of the issue involved in a particular situation, at least he needs to give a notice to the employee, unless it's termination under Article 40.
Yes.
In that case, there is no notice required. It doesn't matter whether it's first offense or second offense. The employer can go ahead and terminate the employee under Article 40. It's
without any warning.
Without any warning. And even it's a very serious sort of provision under Article 40. If there is any termination happen under Article 40, we will discuss what are the grounds in a later stage. But if there is any termination under Article 40, and if employer is justified to take the decision, he can take the decision of termination even without giving any sort of benefits as an employee is entitled otherwise under the labor law.
So when you're talking about Article 40, what are the offenses, some of the offenses that you may remember are mentioned that our viewers would know that this is something that they should never, commit, or this is the offense that is not permissible?
Sure. Actually, as we know, the labor law in the Sultanate is very pro-employee. It's mostly in favor of the employees. And it's been the case since the law has been adopted. It's since the practice in the court, the way the court interpret and view the provisions of the labor law, they try to safeguard the rights of the employees. However, there are scenarios which are allowed for the employer to take the action. We are referring Article 40 termination. It's a very radical sort of actions to be taken by the employer as long as the conditions are fulfilled. There are around 7-8 grounds mentioned and the situations where an employer actually can go ahead for termination under Article 40. For example, if the employee has taken a false identity when he applied for the job, maybe he submitted false or forged certificates. Sometimes we see, unfortunately, these sort of matters come out. Maybe the employee has been with the employer for some time, 1 year, 2 years, 3 years, but during the course of employment sometimes comes out, it pops out the certificate given by the employee for that particular job is actually forged on. It's not the genuine certificate. So this is one reason if the employee takes a false identification. And the second is if the employee commits assault, if he assaults any employees or even the manager or the employers in the workplace, that will be another ground for the Article 40 termination. And most importantly, there is the last ground of Article 40 termination if there is a gross misconduct by the employee. The remaining grounds mentioned in Article 40, those are very specific. The assault, drunken behavior at workplace, is not complying with the safety procedures at the workplace. Those are very specific. But this ground 9 under Article 40, this is a gray area. The word is being used is gross misconduct, and it can take within its purview a lot of things that the court can view as a gross misconduct. Though, out of our practice, we have seen the court actually not readily interpret in disadvantage of an employee, saying, whatever you have done is a gross misconduct, and the employer is actually justified to take the action. There are instances, if you ask me, what constitute a gross misconduct. So out of our practice, for example, it's a case law, it's already established by the appeal court in the Sultanate. One employee, he torn the paper in front of the line manager, and he was supposed to do a particular job. He denied to do the work, and he torn that paper. There was an official document, and then he was terminated under Article 40.
Of course, gross misconduct.
Yeah, on the ground of gross misconduct, and the court accepted the plea of the employer. Yes, this particular scenario actually constitute as a reference to the gross misconduct.
Right.
So yeah.
Right. So I'm glad that you actually told us some of the really important point that falls under Article 40, because people, they know that there are some offenses that are not forgiven for. And it's very hard. Now everything is available on internet. Everything is just written there. But it's really nice of you, Mr. Yassin, to actually, explain one by one, and especially this gross misconduct, because people wouldn't know what is misconduct, how to, elaborate on that. So thank you so much for that elaboration. Now, when an employee is terminated, or how does an employee know that he's illegally terminated, and how does he go about contesting in the court? What exactly is his or her right in this matter?
First of all, the employee should take legal advice. It's very important. Sometimes we disregard the initial consultation with the concerned law firms and try to make our own opinion, which may not be correct given a particular scenario. So the good thing will be for an employee who has been terminated to have a consultation with a law firm, have his case assessed by a specialist lawyer in employment law. And then he can make the decision what are the positives and what are the negatives in terms of the merit of his case, whether what are the rights he should be getting under the labor law, and whether the decision of the termination by his employer is lawful or unlawful. So these should be referred to the practicing law firm, and the proper advice should be taken initially, so that if it has a good merit, so the employee or a particular person who is aggrieved with the decision can take an informed decision whether it's legal or illegal, and then he can proceed with the litigation.
Right. And now, once an employee is terminated, Mr. Yassin, a lot of times the employees are not aware that they are liable to certain perks and privileges, even though they are terminated. What exactly are those perks and privileges? What are those liabilities that are owned by an employer to the employee after termination?
Well, in terms of the rights of an employee who has been terminated, so upon termination, within 7 days from the end date of his service, so the employee should be getting certain rights, his salary, and also his outstanding any payment, and also the end of service benefits, and if there is any annual leave left, he can also get the compensation for unused annual leaves. And on top of that, of course, depending on the company, there might be some other privileges in terms of the two bonuses yearly. There are companies in the Sultanate who are very pro-employee and provides extra benefit in addition to the entitlement in the labor law. So those sort of privileges also he will be, taking from the employer upon his termination. In terms of liabilities, as you were talking, of course, if he has any sort of company property in his possession, either it's a mobile SIM or it's a mobile or it's a laptop or any other official document in his possession, he should hand over to the companies. And also he should take a proper note that all the documents, all the positions with him has been properly handed over to the concerned employees of his employer. Who will be taking the handover.
Right.
So on top of that, an employee who is under termination needs to see the contract of employment as well, whether there is any clause which survives even after termination. For example, if there is any confidentiality clause in the employment agreement, which prevents him from disclosing any sort of information of his former employer, that should be taken care of very strictly. Because out of practice, this sort of confidentiality clause has been enforced by the court, and in that case, if the employee is not careful, he will be, very likely he will be in trouble.
Right.
And also, there is another provision because of the NOC matter has been scrapped, and this is another approach being taken by the employer to enforce or even to safeguard their rights. There is a non-solicitation clause they're including very recently in the practice by the employer. They're including non-solicitation clause in the employment agreement, saying that the employee should not be solicit away any company or business from the company upon termination and going forward. Okay. So those sort of things should be taken care of, and the employee should be reading the contract of employment, particularly those clauses which are likely to survive after the termination, and he should be abiding by those clauses.
All right. Mr. Yasin, I know this is not something that usually happens, but in your experience, have you ever come across any cases that where a person was terminated or a person resigned and that termination resignation was pulled back after acceptance? Does that usually happen?
Well, out of our practice, I can just refer to a case law. It was very interesting. There was a case, the employee, he submitted his resignation, and then he continued working with the company during the COVID situation. Of course, he's been in contact with the clients, his company clients, and he's been discussing with the prospective clients as well on different projects. And the communication was mainly on email, but it's been official email and communication. And so, because of the dispute with the employer, an employee submitted the resignation, but he continued working from home during the COVID-19. And finally, the matter referred to the court. There was a dispute about the whole issue. There was some outstanding salaries and other matters. So the employee, raised the matter with the court, has been in the litigation. And finally, the court said, no, the employer is liable to pay for the employee even for the time after the termination, because he was
still working.
He was still working. He was in continuous employment for the employer, and his email communications and other sort of contact with the clients of the company has been regarded by the court being in the continuous employment. So yes, and that was a huge sort of victory for the employees, because of course during the COVID-19, as we know, there was a lot of stress.
Yes.
And yes, I can see the relief he actually got after the judgment. Yeah.
As you said earlier, Mr. Yasin, the labor law here in Oman is pro-employee. So they make sure that the employees are getting their rights. The judgment is always fair and in their favor.
Yeah.
So I think that's one of the reasons that, you and I and people around are seeing such cases happening. Now we are talking about the liabilities and what is actually owed to the employee after the termination. There also comes a time, I'm talking about expats in particular, that after they are asked to leave from their job, they are usually sent back to their respected home countries. So what happens in that case, that if there are, liabilities, if there are things that are owed by the employer to the employee, how does that work with the employee who's not in the country?
Well, generally, the process of an employee, the process of raising the matter to the appropriate authority by an employee regarding his rights and benefits in relation to his employment is to raise the matter with the ministry. The first step, the Ministry of Manpower. And after that, if there is no settlement happens with the employer regarding the benefits and other matters which are outstanding for the employee, then the matter will be referred to the court. This is the general practice. And when the employee is here remaining in Oman, this is what the way we actually process the whole application at the end, till the end of the matter in the court. For someone who is not present in Oman, still, the rights are there. The law recognizes the rights of an employee under different provisions, as we discussed what are the rights and the liabilities. And those rights remain and stand valid even if that particular employee is not here in Oman, even if he is outside. Okay. In that case, what I would advise, before taking any sort of decision, because litigation at the end of the day, it's a long-term process, and whether you are psychologically and financially, can whether you can bear with that whole process, that's also a matter to consider. So I would advise, before a particular person goes through that process, should take a written opinion, an opinion from a lawyer, get the matter assessed by a lawyer, take an expert advice, what are the merits and demerits, right, what are the positives and negatives, and in terms of winning, what are the percentage that you will be winning the case. Just to have all the information relevant, and take an informed decision. So after the employee has their opinion from the law firm or from a lawyer, and then he can just issue a power of attorney from anywhere of the world. It's very straightforward. Okay. Yes, there are some procedural requirements how a power of attorney should be executed. Depends which country a particular person is and what are the procedures there. As long as that procedures are complete, he can just send over the power of attorney to the lawyer in Oman, and the lawyer will take care of the matter from there.
And he or she doesn't have to be here in physical to solve the matter.
In most of the cases, the way the practice is in Oman in relation to the employment matter, the court actually does not require the employee to be present in Oman. Particularly after termination, if there is no job, no salary, that employee cannot survive in Oman. And that time in the court will take 7-8 months, 1 year, depending on the matter has been dragged to the appeal court, going further. So generally, the employment matter finish within 3 to 5 months. Okay. This is the policy of the government. Try to get the relief as quickly as possible. That's why the government also start the process with the ministry to settle the matter before it goes to the court. So that's the policy of the government, of the Sultanate, and it's very praiseworthy. But at the end of the day, if the matter goes to the court, it takes time, 3 to 5 months in the primary court, and if it takes some more time, if it goes to the appeal court.
Yes.
So it will be very difficult for an employee to survive in Oman without a job. So in that case, yes, if he leaves the Sultanate, but if he gives a power of attorney to a lawyer in Oman, so still the matter can be taken care of. Yeah.
Also, on that note, Mr. Yasin, is it true? I have seen few cases here that once the termination happens, or once you are asked to leave from your job and your visa or your contract is expired, you get a legal document from the court saying that there is a legal process going on, so the person is legally staying in the country, although the resident card or the visa is expired. So that is also another thing.
Right. Yes. I mean, if the employee is here, the aggrieved person is in Oman, by the time the case is going on in the court, by that time, if the visa expires, as you said, as long as the matter is in the court pending to the court decision, that particular employee is staying validly in Oman. He's not overstay, and he's not violating any conditions of his stay in Oman. So,
right.
Yes.
Well, thank you so much, Mr. Yasin, for answering to all the questions that we had for you. I'm sure the viewers now have a clear picture of how the illegal or legal termination gets in place and what exactly are their rights and how they can proceed with illegal termination if the matter is not resolved within the company. Thank you so much once again for taking out time and joining us. It was a pleasure having you.
You're welcome. Yeah.
For more interesting videos and updates, stay tuned and keep watching TTV.